All right, guys, thanks for joining me. It's been a couple days since we've had a live, so let's have one here. Hopefully, you guys will be able to get the message. It looks like there's slow connection. Sorry, I'm at the mercy of the hotels and their connection speed. So hopefully, this message comes through. We've got YouTube, we've got Facebook, we've got TikTok. Thanks for joining me, TikTok. Guys, if you guys can share this, please share it as much as we can before they say that it can't be shared anymore. You know, they tend to do that with me an awful lot here. Where are we at? Well, you guys, you know, we've served 39 states now, right? With notices of crimes that are being committed by agents of the state. We provided notice to the top executive officer, to top judicial officer of these states, the Supreme Courts, as well as also the Attorney General. And it's a simple scenario, you guys. This is simple, okay? A state has no authority to enact its own alternative legislation, substitute it for the guarantees of the Constitution, and then go out and enforce that. I mean, you know, basic civics class will tell us that the supreme law of the land is the Constitution for the United States of America, right? And what it says is that procedures and processes established and codified that all states must adhere to. You see, a sovereign state is a state that is complete in itself, not subject to a higher government's laws. So the rhetoric that we get from the states every single day, where they say that, oh, you know, it's a state issue and it's not valid. States cannot be sovereign because states gave up their sovereignty to join the Union and subject themselves to the supremacy of the United States Constitution. So this discourse that we get every day about states being sovereign and their immunity is absolutely frivolous. It has no legitimacy whatsoever. This goes back to the very first case that the United States Supreme Court ever heard, a case called Chisholm versus Georgia. Let's talk about sovereignty, guys, because you guys got to understand, you know, where it came from and how it can be defeated. So a confederacy is what we were originally as a nation. 1776, when we declared our independence, we were a confederacy. A confederacy is defined as two or more sovereign states with a loose, decentralized governing structure, right? So with a sovereign state, there's nothing that requires them to actually, implement the laws that someone else makes, because they're not subject to a higher government's laws, right? The states associated with the confederacy because they're sovereign. States cannot be sovereign because they gave up their sovereignty when they joined the Union and subject themselves to the supremacy of the United States Constitution. But there were three main issues that our country was facing at the time when we were going into the Constitutional Convention, and those three issues we had to get addressed. The first issue was that the states were picking and choosing what laws they wanted to implement, not implement, that were enacted by the central government, right? So the central government come together, they would create a law, and then they would say, okay, this is what we're going to do, and then the states, you know, the 13th original, they were sovereign, and they were able to say, oh, we don't want to do that. That's not in our best interest. And, you know, so they were picking and choosing what laws they wanted to implement and not implement. So the first issue that they had to get addressed with the Constitutional Convention was, how do we make it so that the states have to actually do what the central government implemented? And they did that by creating the first branch of government, the legislative branch. We have a representative government that is represented by all of the 50 regional governments. They come together, they create a law, and then they federate those laws out to each of the regional governments for application and administration. That's the way it's meant to be, right? So the states don't have the authority to pick and choose, you know, what they want to do or not do, because the central government is represented by each of them. The first issue was resolved by the establishment of the first branch of government, the legislative branch. The second issue was that there was no executive officer to oversee the implementation and application of laws at the state level, right? Thus, they created the second branch of government, the executive branch. His responsibility, his duty is to make sure that the laws are actually implemented from the central government out to the states. That's what his role is, right? Now, the third branch government, or the third issue, was that there was no judicial authority that would make decisions that would impact each of the regional governments. Thus, we created the third branch government, the judicial branch, right? This is three separate but equal branches of government to resolve these three issues that we were facing at the point in time when we were trying to migrate from this confederacy into the union. Now, you guys, a union is defined as two or more non-sovereign states with a centralized governing structure. A non-sovereign state is defined as a state that is not complete in itself, subject to a higher government's laws. You see, the states aren't sovereign. They were never sovereign. And this was a decision that was made by the Supreme Court, 1793, Chisholm versus Georgia. This was a 4-1 decision by the court. There were 5 justices on the court at that point in time. Chief Justice John Jay as well. But the court decided at that point in time that the states gave up their sovereignty to join the Union and subject themselves to the supremacy of the United States Constitution. That was the decision that was made, right? Chisholm versus Georgia. You see, Chisholm was suing the state of Georgia for failure to pay bonds. And as a result, the court came out and said, yes, Chisholm, you can sue, and he ultimately prevailed. So all of a sudden now, it's determined that states are not sovereign, that they can be sued or sue, right? And this created a little bit of pushback from the states. So 1793, Chisholm versus Georgia says, states, you are not sovereign. And all of a sudden they're not. Now, then all of a sudden we get the pushback from the states. The states say, oh no, we would have never given up our sovereignty. We would have never joined the Union had we known that we were giving up our sovereignty and we weren't able to do whatever we wanted. And so then, right or wrong, we passed the 11th Amendment. Right or wrong, we did it. I would say that it's wrong and we need to readdress that. But nonetheless, we passed the 11th Amendment. Guys, what the 11th Amendment says is it says that a citizen in one state cannot sue a different state. All it did was it technically overruled the Chisholm issue, right? But nowhere in the 11th Amendment does it say that you cannot sue your own state. Nowhere does it say you cannot sue your own state, right? Read it. Read the 11th Amendment. So now 1795, 11th Amendment gets passed. All of a sudden, you can't sue a different state, which is why I am out here serving these states right now, you guys, because I can't sue the state of Vermont, right? But there are people that are affected in the state of Vermont in the same way that these other states are affected. Therefore, I can't sue, but there are certainly people within the state of Vermont that can sue. We are enjoining these people into the federal litigation that I have against the state of Washington. If I beat the state of Washington, then all these people that have been joined, through these notices to the highest executive and highest judicial officer within the states, these states are enjoined. They're part of it. And if I can successfully litigate against the state of Washington, which I can, then what's going to happen is that through these people that we're bringing and we're serving notices on behalf of at the state level, through them, we will be able to provide relief to all the people within these states that are affected in the same way, you guys. That's how we create an atoll. That's how we create a class action suit. That's all I'm doing, you guys. I'm creating a class action suit so that all of you can get the relief that you're entitled to once we beat the state of Washington. We're going to beat it. It's no problem. That's not even a question, right? But we have to get these other states to join. We have to bring them in so that we can provide relief in for you guys. These people that I'm serving on behalf of at the state level, through them, we will provide relief back into each one of these states, right? So we've already served the state of New York. We did the state of New York on behalf of Donald J. Trump. We served it on the state Attorney General on June 3rd, and then we served on the state Supreme Court on June 6th, and then on September 6th, we served once again on the state Supreme Court on behalf of Donald J. Trump. So, 1795, we come out, 11th Amendment, we say, oh yeah, states are now sovereign, but they're only sovereign because from a citizen in one state suing a different state. That's why I have to get out here and do this, right? So then we have a whole period of time, almost over 100 years, right? Where almost 100 years, where these major Supreme Courts, or cases like McCulloch versus Maryland, Cohen versus Virginia, Martin versus Hunter's Lessee, all of these major landmark cases from the United States Supreme Court, they all say that the states are not sovereign, that you can sue. If you went through and you read those cases, they all specifically state, oh yeah, states can be sued if you reside within that state. I can sue the state of Washington, right? I can, but most of the people cannot. But nonetheless, I cannot sue the state of Vermont, but there are people who can. Right? That's why we're serving, bringing them together, because this right here creates the class action. This is creating a toll, and that's what we're doing, okay? That's what we are creating the class action. But we have 100 years almost of cases, major landmark cases at the United States Supreme Court, where it says that you can sue your own state. They're not immune. And then you fast forward to 1890. 1890 was the Hans Court, right? And with the Hans Court, what happened was they, the Wake Court. Hans versus Louisiana was with the Wake Court. And what the Wake Court decided was in this particular case, Hans was suing his state, Louisiana. He was rightfully able to sue because you can sue your own state. So Hans was suing the state of Louisiana, and the Wake Court, they wanted to create sovereignty, right? This was what they wanted. And there's a reason why. I'll come back to that in just one moment. But what the Wake Court said in the Hans versus Louisiana case was, we don't read the 11th Amendment literally. We read it figuratively, and we believe that its intended purpose was that the states were to be sovereign. Now, I'm paraphrasing on that one, but that's essentially what it says. So they said that we don't read the 11th Amendment literally. We're not going off of what it says, but we are going to interpret it however we see fit, and we believe that the states are sovereign, thus sovereign immunity is born. It was born in 1890 by a ruling from the United States Supreme Court, right? Nowhere in the Constitution does it say that you can't sue your own state. Nowhere, guys. Get out there and read it. It's only 4 pages. It's not difficult, okay? Nowhere in the Constitution does it say you can't sue your own state. Now, the problem is that the Supreme Court of the United States has no authority whatsoever to be able to amend the Constitution of the United States. If you want to know how to amend the Constitution, you will go to the special amending procedure of Article 5, and it will tell you exactly how to do it. And it has nothing to do with the judicial branch. The judicial branch has no constituted authority to create law or to amend the Constitution of the United States. And as a result, what they did in 1890 is absolutely unconstitutional, because they amended the Constitution in an other than lawful manner. Guys, sedition is defined by blacks as the speaking or writing of words such as law established in order to cause disaffection to the Constitution to procure its alteration in an other than lawful manner. If you create a law, right, and you amend the Constitution in any manner other than what is prescribed within the special amendment procedure of Article 5, you just committed a seditious act. You committed a seditious law. And sedition is committed by traitors to the nation. So Hans versus Louisiana is sedition. It's a seditious law where the judicial branch created a ruling and erroneously called it law, believing that they're able to alter, amend, or destroy the Constitution of the United States through their judicial rulings. Judicial rulings have no authority to be able to create the law. This is the heart of our issue. This is the heart of our argument. You guys got to understand this, because if you don't, then you're never going to be able to comprehend what it is that I'm trying to do out here. The Supreme Court of the United States cannot amend the Constitution of the United States of America. They cannot do it, ever. In any instance, for any reason, they cannot do it, because the only way that the Constitution of the United States can be amended is through an authentic act of the people in accordance with Article 5. All right? Any other way is an act of sedition. And yet, here we are. Right? Here we are. So one of the things that we have in our favor on this whole immunity issue is in 1996, there was a case that came forward called Seminole Tribe of Florida versus Florida. And it wasn't that they overruled sovereign immunity, but what is telling is the dissenting opinion written by Justice Souter on that court. What Justice Souter said in the dissension is he said that there appears to be 2 versions of the 11th Amendment. One enacted by the people in 1795, the other conceived by this court almost a century later. conceived by this court. Well, the judges have no authority to conceive law, right? They have no authority to conceive an alteration of the Constitution. Guys, sovereign immunity is bullshit. It's fucking bullshit. It's not real. It's not valid. It's never been valid. But the Supreme Court of the United States created it through a ruling in 1890 by a court that was sympathetic to the slavery institution. Do you want to know why sovereign immunity exists? Let me tell you why. Because in 1865, we passed the 13th Amendment, right? I'm sorry, 1868, we passed the 13th Amendment. Now, the 13th Amendment was meant to abolish slavery, right? We just had a war, and that war, 1 million people died in the battle for equality, believing that we were destroying the slavery institution. That was what happened, and that's what the people believed, is that slavery doesn't exist here in America anymore. That's not true, right? Because the 13th Amendment doesn't say you can't have slavery, right? The 13th Amendment says neither slavery nor involuntary servitude shall exist except as punishment for crime. Well, the moment that you say except, it means that you can have slavery, right? You cannot have slavery except for a punishment for crime. So what we did was we created an amendment that says that you can have slavery as long as you call it justice, as long as it's a punishment for crime. Well, if that's true, then what happens is that the slave owner is no longer Bill's and Bob's cotton picking farm. It's now the state. The state is now the slave owner, right? It's the slave owner. So who creates a law? Who determines what is or is not criminal behavior? That would be the state. Who investigates what is or is not criminal behavior? That would be the state. Who brings the accusation against you for what is or is not criminal behavior? That would be the state. Who judges whether or not you're guilty of this behavior? That would be the state. Who profits off of your labor? That would also be the state. Therefore, it is the state that is the slave owner. Justice Waite knew this, right? He knew this. His whole court knew this. They were sympathetic to the slavery institution. They made statements to the effect that making a white man have to eat with a black man would be a whole nother kind of slavery, right? He made the statement that the 14th Amendment may be on the books forever, but we intend to make it a dead letter. Chief Justice Waite had an intent to advance and preserve the slavery institution. But the problem is that the only thing that can own property or the only thing that can own slaves would be a person, right? A person. A person must own the slaves. So in a couple of rulings that Chief Justice Waite did, his court did, they preserved the slavery institution. One of those rulings was called Santa Clara County versus Southern Pacific Railroad. Santa Clara County versus Southern Pacific Railroad. In this case, they made a statement, right? Chief Justice Waite made a statement before the oral arguments were heard, a statement that had nothing at all to do with the actual oral arguments or the issue pending before the court, right? But what he said that we, and he was referring to the 9 justices on the court, he said that we are all under the belief that this corporation is protected by the Equal Protection Clause of the 14th Amendment, right? Well, the problem there is that the only thing that's protected by the Constitution is a person, right? A person. So if a corporation is now protected by the Equal Protection Clause, then guess what happens, guys? The corporation is now granted personhood. This is where personhood for corporations came from, was this case, an arbitrary statement made by Chief Justice Waite before the oral arguments were heard by saying, oh yes, this corporation is protected by the Constitution. Thus, personhood is born for corporations. Now, why did he make that decision? Did he make that decision because it was the right decision? Did he make that decision because Southern Pacific Railroad needed to be a person? No, he made that decision because only people can own slaves. Only people can own property, right? And a corporation, remember guys, the state is nothing more than a corporation. So by making that ruling, what he did was he granted personhood onto the state because the state is a corporation. So now we have the state as a person because corporations are people. and only people can own property. So he was preserving the institution by granting the state personhood. Now the person owns the slaves because the slaves have now been transferred into the state custody, state possession. It is their property. So we granted personhood onto corporations. We did it to make sure that the state and the institution is preserved. It was a decision made by weight, had nothing to do with the case whatsoever. But we know from 1857 and the Dred Scott ruling that slaves are private property protected by the Constitution. Waite wanted to preserve that. Want to make sure that these slave owners, that the new slave owner being the state, that they're now protected and preserved by it. So we had Chief Justice Waite made this deceptive ruling, granted personhood under corporations. States are nothing but corporations. Now the corporation is a person. You guys want to question why it is that the state is coming against you, right? Why it is that the state is your opposing, your accuser? This is why. This is why. Because the state is granted personhood by an arbitrary and capricious ruling that had nothing to do with right or wrong. It had everything to do with preserving this fucking institution. Here we are, okay? The state can bring an accusation against you because the state believes it's a person. This is also the way we're going to defeat them, right? Because as a person, myself, right? I have a whole bunch of different parts, right? And if my hand goes out and it steals something, my head cannot say to the hand, oh, it wasn't me that did it. You can't punish me. No, the person is going to be punished for any criminal act of any part of this body known as Tanawah. We get the same thing now with the person called the state. Because that state is one person. One, which means it's made up of a lot of parts, a prosecutor, a judge, CPS, law enforcement. They're all part of that body. Therefore, when the state brings an accusation against you, it is one, not many, but one. Therefore, we only have to find one crime committed by any part of that body of the state, and that whole person must suffer for any individual act committed by any agent of that person known as the state. This is why they're so fucking scared of this, you guys. Because we only have to identify one crime committed by any part of that body known as the state. And when we do, the entire state must be punished for that individual act. And herein lies the creation of the criminal conspiracy. The state can't have it both ways. You can't say that I'm a person and I can bring accusations against you, but then in the same breath say, oh yes, but I'm government, right? And I'm immune, because that's not how shit works, state. That's not how it goes. You don't get to have it both ways. You can have one or the other, but if you're gonna bring an accusation against me, then I get to come against you, and that means the entire body. So judge, when you cover up the crimes committed by the police officer when he murdered someone out of the street, then guess what? You're just as culpable in that as anyone. And any part of the body commits a crime, the entire body must suffer for each individual crime being committed. Guys, we've got them up against a wall, but we've got to come together. We've got to fight this in a very, very specific way, right? The state believes it's a person. They believe it's a person because they're preserving the slavery institution. There's number one, okay? So now that's Santa Clara County. Now, why did Hans versus Louisiana? Why did they say that the states are sovereign? Because they had just granted personhood on the states. The states can own property. And guess what? They don't want you to be able to sue your slave owner in federal courts for your freedom. Thus, they said that the states are now sovereign. They did that through Hans versus Louisiana. All Hans versus Louisiana did was it made the slave owner immune so that you can't sue him in federal court for your freedom. It memorialized the Dred Scott ruling from 1857, where Dred Scott came forward and said, oh, can I sue in federal court for my freedom? And they said, oh, no, you cannot, because you're a slave, and a slave is not a person. Get out of here. You don't have standing. It's the same thing. Waite took the lessons learned from the Dred Scott ruling, and he memorialized them into law, what he called law, case law, by directly amending the Constitution of the United States and making that slave owner immune. You guys, that's exactly what they did. That's all that they did, right? This court, the United States Supreme Court, they've been covering up their lies for 243 years, and we need to understand that, okay? So, love me, hate me, I don't care, you guys. It really doesn't bother me anymore. I mean, I've heard enough about what people think about me that at the end of the day, you guys, that this damn court, all that I'm trying to do is get you guys to understand that they're a bunch of pieces of shit. You don't gotta honor them. They're criminals that have been covering up their lies for 243 years. These justices, they know exactly what I'm talking about. They know exactly what was done, and they don't want to admit it. But you know what? Just because you don't want to admit it doesn't mean that it's not going to be heard. I'm out here and I'm trying to tell you guys, I'm trying to teach you guys, I'm trying to inform you guys of why this stuff exists, why this stuff is happening. And when you guys fight with me and argue with me and tell me that case law is the supreme law of the land, like I've had and heard numerous times, you know, that you lose all credibility with me when you make that statement, right? You know, I'm not going to bring up any names, but I'm constantly out here arguing or having people that are creating videos that are saying, oh, this Supreme Court case ruling, this the case law says this. That's not fucking law. I fight from the Constitution. That's the only thing I fight from. That's why I'm effective. That's what I was taught. Anything that's not the Constitution is unconstitutional simply by virtue of the fact it's not the Constitution. Anything that's not the Constitution is unconstitutional. And if you guys learn anything from me, if you take away anything at all from the things I say, take away that truth right there. Anything that is not the Constitution is unconstitutional. So anybody who wants to argue with me about case law, right? Or anybody that wants to argue with me about state statutes or state constitutions or even United States code, I'm going to say to you, you have no credibility with me. I'm sorry, but you don't, because I'm arguing from the highest form of law, the Constitution, and that's what I want all of you to argue from as well, because once you argue from that, they shut up. 39 states I've served with this notice. 39 state attorney generals, 39 state Supreme Courts have got nothing to say. Nothing. There is no counter argument. Any unrebutted accusation is truth, guys. We've got them by the balls. We've had them by the balls for the last year, right? There's no counter argument. They have nothing to say on this. So again, what I'm doing is we are using a very, very big issue. Right? We're using a facial constitutional violation in order to bring about an understanding about a much, much bigger issue, right? Much, much bigger issue. So that's a great question on who's going to enforce it. And I know how it's going to be done as of this moment, but I'm not really ready to explain quite yet. We've got the justices. We've got justices that are in support of this. They just don't have the balls yet to step up and do what they need to do, but we're going to make them. They're going to get there. And remember, you guys, we only need one. One justice is all that's necessary to sign the writ, and by doing so, we will fix it. Now, so I'm going to go ahead and I'll hit Trump as of this moment, guys. You can love me, hate me. Once again, I don't care. It doesn't matter to me, right? I'm support of Trump. I'm naturally conservative, but I'm going to tell you what's going on right now. And whether you like it or not, I want you guys to sit and I want you guys to listen to this, okay? I want you to hear what I'm about to say. On June 28th, we had the ruling called Chevron, okay? Chevron ruling. Chevron was all about the Supreme Court of the United States came out and said, executive branch, you cannot do whatever you want to do, okay? You cannot do whatever you want to do. That was the ruling on June 28th. The very next week, before we went into the 4th of July holiday, the very next week, the Supreme Court came out with the Trump immunity case. And they said, executive officer, you can do whatever you want to do. Okay? Guys, those two rulings are in direct opposition with each other. Direct opposition. Why is it that you guys are not questioning that? Why is it that you're not saying, wait a second now, what is going on here? 1 week they say executive branch, you cannot do whatever you want, but the very next week they say executive officer, you can do whatever you want. Why? Why did they why are you guys not questioning that? You should be questioning that. Those two rulings are in direct opposition with one another. I knew when that ruling came out, when the immunity ruling came out, I knew that there was a problem. I knew that there was a big problem, right? Because the court had already agreed to hear my case, but then they reneged on that, went back and said, okay, we're not going to be able to hear it until after the election, right? So now there was an emphasis on election, right? And I knew it. I knew that there was something wrong the moment that Trump immunity ruling came out, because it's in direct opposition with Chevron. You know, you all got excited with Chevron. You're like, oh my God, this is the answer to problems. And it was. But here's the problem, right? I knew that there was a quid pro quo. I knew that there was something wrong with that ruling. And I didn't know exactly what it was. Now remember, right? Remember that I left that morning of the Trump immunity ruling. I was in DC and I left. I was nervous about being local, about being in DC, and I got the hell out of there and I rode down south, right? And a week later, I'm sitting on my back on the interstate with the cut forks on my motorcycle, right? The day before the Trump's attempted assassination, July 11th, I'm sitting on my back on the interstate after the front tire falls off because the forks were clearly cut. We see that, okay? So, but I walked away from that, survived. So we had a ruling that was the correct ruling that said, executive branch, you cannot do whatever you want to do. What was that about? That was the judicial branch telling the executive branch that we're going to have to deal with this problem. We're going to deal with this indictment by a grand jury issue. But prosecutors, you may not continue to bring to us the incorrect charging instrument because our judges are now implicated in this. That was the judicial branch notifying the executive branch that they are no longer going to participate in the criminal conspiracy. That's what that was about. Okay, that's what that was about. So issue number one was, hey, we're going to notify the executive branch and tell them they can't do whatever they want to do. We're no longer going to participate. That was the judicial branch providing affirmative action to them, notifying them that they're no longer going to participate. That's what Chevron was about, because they knew that they were going to have to deal with this indictment issue. That's issue number one. But then the very next week, they come out and say, Trump, right, executive officer, you can do whatever you want to do. I didn't know what it was about, right? As of that moment, I didn't know what the quid pro quo was. But you know what? I do now, right? I do now. So last week, or 2 weeks ago, we saw a memo that came out from DOJ, right? Everybody across TikTok and across all these platforms are all like, oh my God, this is the answer. It's the answer to our problems. It's the same shit that you guys did with Chevron. You guys were so excited, like this is the answer, right? But was it the answer? No, they haven't changed shit. They haven't done a fucking thing to fix the problem. All they did was put out a ruling telling you guys we're gonna, and then you guys got all excited and happy and like, there's the answer. This is the fucking truth, and guys. The DOJ memo was not what you think it was either. You guys got to remember, I'm an expert in government diversions, right? I was trained by them. I know how they work. I know how to fucking see government diversions. This is a diversion, right? They're getting you to look over here, and they're saying, look over here because they're going to be doing something on the other side. They're wanting you to look in the wrong direction. It's a diversion, right? And they're doing it intentionally. This is what the diversion is, you guys. Here it is, right? Love me, hate me, I don't give a fuck. I'm going to tell you guys the truth. You guys can accept that as the truth, but I want you guys to understand that what is happening is not what you think it is. You need to look at words and actions. They have to align. If they don't align, then they're not telling the truth, okay? And you have to understand they're not telling the truth. So if they believed that these judges were not constitutional, then why is it that last week every single prosecuting attorney was in the courtroom working with these unconstitutional judges, right? Prosecuting on information, prosecuting people that were unlawfully and unconstitutionally arrested. Why is it that it was business as normal for the prosecuting attorneys? If you believe that the judges are unconstitutional, then why are you continuing to send your agents in to work with an unconstitutional a judge, right? Those two actions, they don't align. They're not consistent with one another. And you guys have to question this shit, right? You got to question it. Because if you say that the judges are unconstitutional, but every prosecutor works for the executive branch, then why are you permitting your agents to continue to go in and work with them every day this last week? If they're unconstitutional, then everything that they're doing is unconstitutional. So why are you continuing to work with them? That would technically be misprision of treason, because you came out in a memo and you said that they're all unconstitutional, and yet you're continuing to work with them. Attorney generals, you're continuing to work with them. Prosecutors, you're continuing to do business as normal, working with an unconstitutional judge. Those words and actions, they don't align, you guys. They do not align. Right? They don't make sense together. So here's the problem, all right? If you guys buy into this, if you accept what they're saying, the narrative that's being presented to you, the looky-loo that's being given to you, and you accept that these judges are under the executive branch, if you guys accept that, then guess what can happen? Trump can grant immunity onto those agents because he was granted immunity. He can grant immunity onto those judges because they work for him, because he was granted immunity. And in doing so, guess what? Everything that they've done will be valid. If you guys buy into that narrative, if you accept the looky-loo that they're giving to you, then guess what? All of their actions will all be valid because Trump can now grant them immunity, right? Because he was granted immunity. That's what can happen. Now, but here's the problem that I have. If I walk down the street with a water gun and I point that water gun at you and I say, give me your money, I'm going to shoot you, right? You are going to give me your money if you believe that that water gun is real. It doesn't matter whether it's a water gun or a real gun. What matters is how you interpret it and how I present it to you, right? I presented it, or I portrayed it as a real gun. You interpreted it as a real gun. And as a result, what happens there is that you give me your money as a result of the fear and duress I've inflicted upon you by the abuse of my power on what you thought was a real gun. I'm going to go to prison for that. It's called robbery, okay? It's robbery. So what matters is how it's interpreted. What matters is how it's presented, okay? So these may be judges that are only hearing officers. They may very well have worked for the executive branch, but they were portrayed as judicial officers under the judicial branch to you. You walked into that courtroom believing that they were a judicial officer of the judicial branch because that's what they portrayed themselves as. And as a result, do not accept the bullshit that they're telling you that they are a hearings officer. You stick with the fact that you believed that they were a judicial officer. They were under the judicial branch. And guess what? The Supreme Court of the United States never corrected that. Don't buy into the delusion that they're trying to send you over here, because it's a looky-loo. It's a diversion, because they're trying to find a way out of this. They're not trying to find a way through this. They are still trying to find a way to not have to come to terms with what is coming forward from all this, right? They don't want to do it, right? So you can buy into it, you can accept it, or you guys can continue to, but what's happening is it's a diversion. They're trying to get your attention in a different direction. They're trying to get you to accept something very particular so that they can continue with business as normal, because that's what their behavior and their actions is showing. Last week, it was business as normal in those courtrooms, continuing to prosecute by information, continuing to prosecute people that they'd illegally and unconstitutionally arrested and held over. Nothing changed from the executive branch's perspective. It was business as fucking normal. And as a result, I'm not going to accept what they say in that DOJ memo, because their words and their actions do not align with one another. Guys, you guys can see this for yourself. Love me, hate me, I don't care, but I'm just giving you the truth. I'm telling you guys, what's out there. I'm trying to get you guys to look at the actions and compare them to the words, all right? Because they're not aligning with one another, all right? They're not aligning, all right? Driving under the influence, unconstitutional? So the problem with the driving under the influence is who was your accuser, right? It was the state, man. It was a police officer that pulled you over and said that you are intoxicated. The state can't be your accuser, right? Unless the state is a person, just as I said at the very beginning. So no, I mean, technically DUIs are not constitutional. because of the way in which they arrested. There's no person that's accusing you of that crime, but for that officer who pulled you over, did the breathalyzer on you, and that officer cannot be your accuser, because if he is, then the state is party to the cause. You know, you guys, there's a lot of instances in which I would say we probably want to protect society from certain things, right? You know, a great example is the child issue and the right of intimate association. I would agree that there's instances in which we probably want to protect children from abusive families, abusive parents. I would agree with that. But until we get those defined within the Constitution of the United States of America, then you cannot deprive a person of the right of intimate association in any instance, right? Because if the Constitution preserves the right to intimate association, then no state can create any law that interferes with your right to intimate association. In any instance, it doesn't matter what it is. And until we define those instances and we have it codified in the Constitution of the United States, no state can interfere with that fucking particular right. Same thing with this indictment issue, right? If the Constitution says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, then that means that if any state creates a law that permits their agents to hold you over for an infamous crime without first having an indictment by a grand jury, that would be unconstitutional. It would be a direct facial constitutional violation of an enumerated constitutional right, right? There's no instance whatsoever in which a state can hold you to answer for an infamous or capital crime without first having an indictment by a grand jury. None. And yet there's 13 states across country that do not conduct a grand jury at all, right? There's another 28 states that permit their prosecuting attorney to charge by information or indictment by their discretion. Both of those are unconstitutional because the first one eliminates and forecloses upon the use of the grand jury altogether, which is a direct facial constitutional violation. The other one permits a prosecuting attorney or a government agent to decide who gets a constitutional right and who does not, which is a direct violation of the Equal Protection Clause of the 14th Amendment. No state can create a law that permits their agents to decide this person is going to get a right, this person is not, because that would be a violation of the Equal Protection Clause. No state shall create any law that does not provide equal protection of the law. So, you know, we have more than 700,000 people that are currently in prison here across America illegally and unconstitutionally on direct facial constitutional violations. The states did not follow the procedures and process established, codified in the Constitution for the adjudication of a crime, and that means that their convictions are not valid, they are void, wholly without force or effect. They don't even exist. These people are sitting in prison right now on nothing. The only thing that's keeping them there is the fear of standing up and walking the fuck out of that prison. That's it. Right? Because nothing is holding them there in that prison, because there is no valid judgment that exists, because the judgment is void. Void. Because the court lacked the jurisdictional authority to be able to do it when they chose to abridge the obligations codified in the Constitution of the United States of America. Okay? So we're using the indictment issue to get in to have a much bigger argument about some much bigger things. But I got to get checked out of the hotel room, but I want to run through one other thing here, okay? I want to tell you guys about the incorporation doctrine and the history behind it, okay? I'll come back to that YouTube in just one moment, brother. All right. So, I want to get through this. I want you guys to understand what it is that we have to lose here. What it was that we have to gain here. So, the Supreme Court of the United States in 1833, in a case called Barron versus Baltimore, the Supreme Court of the United States, they came out and they said that the Bill of Rights, which is the first 10 amendments to the Constitution, that those are not a restriction against the state governments. Those are only a restriction against the federal government. And as of that moment, it started what was known as the dual sovereignty doctrine. Now, dual sovereignty is the belief that you are both a citizen of the United States and a citizen of a state, and you only get the rights that exist for each one of the two citizenships. So, for instance, when you're in a state adjudication process, you only get what the state gives you, what the state constitution gives you. But you get your federal rights when you're in a federal adjudication process, but you don't get them in both. So if you're in a state adjudication process, you don't get your federal constitutional rights. Okay? You don't get it. Now, this is bullshit. We know it's bullshit, but nonetheless, this is what it is. Now, why did Chief Justice Marshall and his court make that decision? They made that decision because 6 months after Barron v. Baltimore was ruled on, 6 months later, the First National Bank was established, right? The First National Bank. Now, the federal government, they knew that the states were going to sue when this national bank was put into place. They knew it, right? There was no doubt about it. Because the people of the United States, we knew that debt was the easiest way to enslave a nation, right? We were well aware of that as people. So the federal government knew that the states were going to sue the moment that the First National Bank was put into place. So to prevent them from being able to sue, they had to eliminate standing. And to have standing in federal court, you have to, one, be a person or represent people. And two, you have to be directly impacted by the law in question. So by saying that the Constitution doesn't apply to you states, what happened was that 6 months later, after Barron v. Baltimore was put in place, the First National Bank was established. States couldn't sue because A, Constitution doesn't apply to you states, dismissed, you can't be heard. What Marshall did was he paved the way for that First National Bank to be put into place by saying that the Constitution doesn't apply to you states. Now, Marshall was partially correct, right? But he was deceptive in what he did, right? He was deceptive in what he said. Because, you know what? It's true that the Bill of Rights doesn't apply to the states. Because the Bill of Rights applies to the people of the United States, including those people that reside within the state. You see, his statement was deceptive. The Bill of Rights doesn't apply to states, but it does apply to the people, including any person that resides within the state of Maryland, Baltimore, right? So by making that statement, you know, he deceptively led us astray by saying, oh, yes, this isn't a restriction against the states. It's only, you know, a protection, whatever. The people are always protected by the Bill of Rights. Always. Always been, always will be. Doesn't matter where they choose to reside within the jurisdiction of the United States. We are always protected by it. But that's the reason why they put this ruling into place. So 1833, all of a sudden, no one is protected by any of the rights that's within the Bill of Rights. You don't have the freedom of speech. You don't have the freedom of religion. You don't have the right to bear arms. None of this shit exists at the state level. It only exists at the federal level, which at this point in time was the 10 square miles of Washington, D.C. So fast forward now to 1925, a case called Gitlow versus New York. In the case of Gitlow, Gitlow was challenging his freedom of speech against the state of New York, brought it to the United States Supreme Court. The United States Supreme Court came out and said, oh yes, freedom of speech is protected against interference because of its codification in the Constitution's text. So now all of a sudden, in 1925, we find out that we're protected by the freedom of speech. Well, that's a pretty big news for us, because we thought that we were protected for the freedom of speech all the way from 1776 when we declared our right to be able to speak, right? Under the Declaration of Independence. So what happens there is that all of a sudden we are protected against interference, or freedom of speech is protected against interference by states because it's codified in the Constitution's text. Now you would think that the moment that they say that one of the rights that are contained within the Bill of Rights, once one is protected, that they would all be protected, and that's not what happened, right? That's not at all what happened. That started what is called the incorporation doctrine, right? This is what the incorporation doctrine is. So the court started slowly incorporating each of the Bill of rights one at a time in different cases as they came forward. 1958, Miranda versus Arizona was the right to self-incrimination, right? 1969 was Duncan versus Louisiana, the right to trial by jury, right? So we had all these cases that came forward that individually incorporated the Bill of Rights. The last one to be incorporated was in 2019. It was a case called Timbs versus Indiana, Timbs versus Indiana, and that was the right to the excessive fines clause of the 8th Amendment. Last one to be incorporated. Now let me tell you guys, there is one provision left to be incorporated. One. left. All the rest of them have all been incorporated, except for one. And that one left to be incorporated is called the Grand Jury Clause of the Fifth Amendment. This is the last one to be incorporated. But once we do this, once we incorporate this one, then for the very first time in the history of our country, every single person will be protected by every single right secured by and enumerated in the Constitution of the United States, regardless of where they choose to reside within the jurisdiction of the United States. This is the one that is the hardest to pass. This is the one that's hardest to get by, because this is the one that's going to set the people fucking free. This is the one that they never wanted to be able to have to overcome. Now, how have they been able to keep this hidden for so long? That's because in 1925, when Gitlow versus New York came out, 8 months after the ruling in Gitlow, which was in February, 8 months later, which was September, October timeframe, 8 months later, they came out with the Judicial Reform Act of 1925. The United States Congress did. Judicial Reform Act of 1925. Now, the Judicial Reform Act of 1925 was not good. It was absolutely deceptive, and it fundamentally changed everything that you guys believe, and it steered you in the wrong direction by technically foreclosing upon the Constitution through legislative fiat. Let me tell you what they did in 1925. So in 1925, you have a court case, Gitlow versus New York, that comes out and says freedom of speech is protected, right? Well, Congress is like, what did you just say? Freedom of speech has always been protected. It's in the Bill of Rights. And the court said, oh, no, because in 1833, we quit giving the people their rights. We said that the Bill of Rights are not a restriction. And Congress said, oh, shit, that's a big deal. That's a problem, right? We don't want this to come forward. We don't want the people to actually find out about this, because that's a big deal. So here's what we're going to do. We're going to create the Judicial Reform Act of 1925. And in it, we're going to do two things. They're going to fundamentally steer the people astray, right? First off, they said that the Supreme Court of the United States and all the state Supreme Courts are now courts of discretion. Discretion. Meaning that they can pick and choose what cases they want to hear or not hear. So if one of these big cases comes forward, one of these civil rights cases come, then that court could say, okay, I'm just going to ignore it. We're not going to hear that case, right? So they were able to pick and choose what case they want to hear or not hear, which is their discretion, okay? Now, that's the first thing. I'll come back to that in just one moment. But the second thing that the Judicial Reform Act of 1925 did is it told you that the only way that you can petition the court is through a writ of certiorari. Now, a writ of certiorari is a request to review a lower court's decision. Okay, a request to review a lower court's decision. So what a writ of certiorari does is it invokes the court's appellate jurisdiction. Appellate jurisdiction. Because in order to petition that court now, you have to say that there's already a decision that's in place from a lower court, and thus you are invoking their appellate jurisdiction. Why did they do that? They did that because of exactly what I'm arguing. Article 3, Section 2. In all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. You see, there's two different types of jurisdiction for the Supreme Court in the Constitution. One is original, the other is appellate. We're all very familiar with the court's appellate jurisdiction because we have to petition a court to writ of certiorari. We have to have a lower court decision in place before we can go to the Supreme Court, because Congress told us in 1925 that the only way we can petition that court is through its appellate jurisdiction. But if that's true, then why is it that they have an original jurisdiction anytime the state is a party in a cause? If a state is a party in a cause, the United States Supreme Court has original jurisdiction, constitutionally codified, written right there. It's an obligation that exists. And let me tell you, when it comes to a constitutional obligation, constitutional obligations can never be discretionary, and they can never be delegated. That's already been litigated. You may not use your discretion abusively to break the Constitution. So if that court can use its discretion to pick and choose what case they want to hear or not hear, would that not be abusing your discretion by breaching a constitutional obligation when the Constitution says you have original jurisdiction if a state is named a party? The court's been doing this for 143 years, right? The Congress of the United States has been putting in place deceptive acts of Congress that have been leading you astray, right? How is it that you can invoke original jurisdiction in that court if the way that you have to petition them is through a writ that requires a lower court's decision? You're invoking their appellate jurisdiction, which is why I had to find a way around that. That's why I'm using the writ of habeas corpus, is because that's the only way that we can invoke original jurisdiction with that court. Guys, if a state is named a party, in a cause, the only court in the country that can oversee the disposition of that dispute is the United States Supreme Court. No other court has jurisdictional authority to be able to oversee it. A state may not be both accuser and judge in the same cause, ever. And yet look at what they're doing, right? These CPS agents, they are there to enforce the laws of the state. They are absolutely an agent of the state. They're operating under the authority of the prosecuting attorney for that county, right? And as a result, guess what, man? The state is a party, right? In every single criminal matter, is it not state of whatever versus you? State is named a party. There's no denying this truth, you guys. The state has no authority whatsoever to be able to oversee the disposition of a dispute in which the state itself is a party in the cause. If the state brings an accusation against you through one of its agents, that state may not be judged in that case, and that judge has a constitutional obligation to recuse himself, codified in Article 3, and if he fails to do so, that judge is acting without jurisdiction. And anytime the judge acts without jurisdiction, according to Title 28, subsection 455, that judge is warring against the Constitution and committing the crime of treason. Refer to Hill v. Weeks, United States Supreme Court. Let me ask you guys a question. You guys know that I'm not a big fan of the judges. I think they're all pieces of shit. I'm certainly not going to honor them for a goddamn thing that they do until they step up and admit the lies and treasonous and seditious acts that they put into place and rulings that they've erroneously called law. And I'm not going to honor anything. But I will say this, right? Chief Justice Marshall made a statement in the ruling McCullough versus Maryland. And he said that the power of government is defined and limited. And those limits can never be mistaken or forgotten because the Constitution is written. To what purpose are powers limited? And to what reason are those limits committed to writing if those limits may at any time be passed by those that are intended to be restrained? The difference between a government with limited powers and unlimited powers is abolished if these limits are not confined, and if the person whom they are imposed, and if acts prohibited and acts allowed are of equal obligation. It is a proposition too plain to be contested that the Constitution controls any acts, statutes, customs, or rulings repugnant to it, or if the judiciary may alter the Constitution by a simple ruling made by a group of judges intent upon the advancement of industry and not upon the will of the people. The incorporation doctrine is bullshit. But what we have to win here is that when we finally overcome this last provision, when we incorporate the grand jury clause, when we do this, which is what I'm trying to push, I want you guys to understand that this affects every one of you. It doesn't matter if you're a family court issue. It doesn't matter whether you're a guardianship issue. It doesn't matter if you're a criminal issue. What this does is this is going to, for the first time, abolish the bullshit that the judges built and put into place. But we have to do it fighting against the decisions that they put into place. There is one provision left to be incorporated. Once we incorporate it, then we can go back to Barron v. Baltimore and we can remove Barron v. Baltimore as the foundation. Today, the reason why you don't get certain rights within a courtroom, the reason why judges believe they can do whatever they want, derives from an unconstitutional act made by the highest court in the land, and we've got to hold that court accountable for the crimes and seditious acts that they put into place, right? That's what we got to do. So this indictment issue, yes, it deals with prisoners. Yes, it deals, But you know what? By attacking this issue, once we resolve this, the whole Barron vs. Baltimore has been resolved. This is the last one to incorporate. Once we do, we can go back to Barron vs. Baltimore and we can say, remove that bullshit from the foundation, put the Constitution back in its rightful place at the foundation. And when we do, what we're going to see is a massive number of cases are automatically going to be disappearing because they all derive from an unconstitutional ruling that was erroneously called law by the highest court in the land that directed every court within its purview to act in an unconstitutional manner. This is what has to happen for preemption to occur. If you want to put the Constitution back in its foundation, two things must happen. One, all of the bullshit that the executive branch put into place through their policy must be removed. We got that ruling on June 28th, Chevron. But until the judicial branch has all the bullshit that they put into place, all the rulings that they put in that they erroneously called law and direct all the courts to follow their bullshit law that isn't law because judges can't, until we have that, the Constitution is not going to be placed back at the foundation because what we have today at the foundation is judge-made rulings and policy created by the president. Remove those two things and the Constitution will fall back into the place where it's meant to be, back to foundation. And once there, then we can actually see the relief that we're all searching for, that we're all expecting. Then you guys can be happy with what it is that you see because we have a second half that we've got to get addressed. And the only way we can address it is by this indictment issue. We must get this indictment issue incorporated. And once we do, once it's incorporated, we can go back to Barron vs. Baltimore. We can remove it. And every case from 1833 will be deemed unconstitutional because once the Supreme Court of the United States introduced fraud into the court system, the moment that happened, every single thing that every single court across the country is doing is fraudulent. Fraudulent because it derives from a fraudulent ruling, fraud that was introduced by the highest court in the land. The Supreme Court of the United States is absolutely 100% responsible for every bit of this. Their rulings that was put into place erroneously and fraudulently, they are, and until they step up, until this court and these 9 justices step up and direct all the courts to act in a constitutional manner, there is nothing that any court in this country does that is going to be constitutional. Nothing. That's what we have to lose. That's what we have to win here. But you guys got to get behind this and you guys got to trust me. If we incorporate the indictment issue, then I can attack Barron vs. Baltimore. I can remove it. And once I remove it, everything that came after that is all void. Void. Without force or effect, right? I got to get ready to get out of this. We're 20 minutes late from checkout. Guys, what I'm doing right now, we've got 3 states that are left to get served here in the Northeast. I'm in New Hampshire right now. We're getting ready to go out and do New Hampshire. Then we're going to Vermont. We're going to Maine. We're going to get those states served. We're doing it over the weekend here because we have some hearings that we got to get to down in the South by Wednesday morning. But we're trying to continue to get these states served. Trying to get them done. I'm going to have to do it over the weekend, so we're going to be serving state patrol as opposed to the attorney generals or assistant attorney generals, which is fine because state police are still an agent of the attorney general. Because remember, attorney general is the highest law enforcement officer. Therefore, we can serve an agent, being a state patrol officer. We can do that, right? I'm going to be coming across to Maine. I do need something there. Please reach out to me, brother. Send me an email or a message across here. Email is TANAWAHDOWNING@gmail.com. Please rewind, listen to that again. That right there, okay? TANAWAHDOWNING@gmail.com. I do need some help in Maine, all right? And I'll explain to you what I need help with. Thank you for reaching out. Let me know that you're in Maine. Guys, so we're trying to get these 3 states served. Well, thank you, brother. Awesome. So once we get them served, then at this point in time, we're going to have 42 of the states served. 42 of the 50, man. You know? And once again, all we're doing is we're going to the highest executive officer and the highest judicial officer. And we're providing notice that their agents are committing crimes, right? And we're giving them an opportunity to be able to fix those crimes. If they do not want to fix them, then that's fine. That means that they're permitting them to continue. They're sanctioning them. And as a result, every single agent in the state is now served. Massachusetts has been served. Texas has been served, guys. They've been served, right? Texas is already done. I'm gonna be coming back to Texas here in another week, I think, maybe a week and a half. We have some work that we're gonna be doing, and then there's a seminar that I'm gonna be working and speaking at, I believe, middle of April. So I think sometime around April 20th, down in Austin, Texas. So I'll be in Austin for that seminar to speak around that time. So more information to come in the future here on that. So, guys, this is cut and dry, right? The indictment issue is so simple. They're not arguing it. They're not baiting it. It's not. So, Pennsylvania, I have served Pennsylvania. We have served Pennsylvania as well. We're going to be coming back through Pennsylvania. I know that on our way back down south, there was some discussion of me stopping in the Poconos area, meeting with a couple of groups there. That's not confirmed yet because we have this other meeting that we got to be at, or this hearing that we got to be at. Oklahoma has absolutely been served. Oklahoma is the battleground state for us. I actually served the most appians in that particular state when I went in and served Drummond, and I'm very happy to have served the state of Oklahoma. Yeah. Oklahoma, guys, is a horrible state right now. I mean, 1 out of every 4 families has got someone in prison in the state of Oklahoma. That's absolutely insane, right? Missouri has been served. We've served the state of Missouri as well. All right. So the only states that have not been served: South Carolina, Maryland, North Dakota, South Dakota, Montana, and Nevada. That's it. Every other one has been served. Maryland, South Carolina, North Dakota, South Dakota, Montana, and Nevada, and then Alaska and Hawaii. Every other one's been served, right? Every other one. Okay. So, guys, again, I am. It is with Cameron. Yeah. So it's Cameron that I'm gonna be going to. Yeah. I'll be there with Cameron and his group. Yeah. The Wisdom group. So. From what I understand, that is one. All right, guys. So I operate on donation only. You guys know this, and so I can't do this work without your help. And I'm going to ask you guys, please continue to donate. I don't have money. We're very short on funding, but we've been able to remain blessed. We've been able to have a place to sleep at night, food to eat. But please, if you can, if you want to get behind this, if you want to support this, we need your help. All right, I can't do this on my own. All right, I do this full time, and I do this because it's right to do. I do it because all these prisoners need help. And you know what you guys should understand is that standing behind me are 2.9 million prisoners, right? Who are people who had rights. Every one of them had rights that they were entitled by their birthright. Every one of them had rights that were guaranteed by the Constitution of the United States of America. And every single one of them had their rights denied by 40,000 criminals standing in front of me. These judges, 40,000 judges across America, every single one of them are criminals. So behind me are 2.9 million people who had rights and who are protected by the Constitution of the United States. Standing in front of me are 40,000 traitors. Who do you think's going to win? Huh? Who do you think's going to win? We have the numbers on our side. Who I'm protecting and who I'm serving and who I'm fighting for, they all had rights. They're all on the right side of the law. They were all protected by it. And standing in front of us is 40,000 traitors, criminals. Who do you think's going to win here? Who do you think's really scared? If these 2.9 million people get behind me and give me the power to step up to these 40,000 criminals, guys, they don't stand a chance. Not a chance at all, right? So just look at the numbers, right? 2.9 million people who these 40,000 judges had no authority whatsoever to convict them, to bring them into a courtroom because they all had a duty constitutionally codified to recuse themselves. That makes them all criminals, which means that these 2.9 million people can rally behind me and push me up against those 40,000 criminals, and I'll take them all down because every one of them had a constitutional obligation to recuse themselves, and when they didn't, they all became traitors. That is an issue that every single one of these 2.9 million people can get behind. Every single one of them can get behind it. So the submitting the affidavit by email is all right, guys. These post offices are refusing to deliver, right? They're returning to sender. Numerous post office boxes are. So what I'm doing right now is I'm raising awareness. I'm continuing to push forward with knowledge, because the moment that I receive the docket number from the court, which who knows when that's going to happen, but the moment that they give me the docket number, that moment, as of that moment, we will start the final tour. And the final tour is a victory lap around the country. It's what I've been planning all along, the We Shall Be Free tour. 32 press conferences at 32 state Supreme Courts over the course of 40 days, ending in Washington, D.C., where there won't be a single news station in the country that won't be there to meet me, greet me, and watch me as I walk into the Supreme Court to deliver oral arguments on behalf of people in the United States for the deprivation of rights and freedoms that have been robbed from them by this government. That's what we've been planning for 3 years. That's what we're preparing for. And that's when I'm going to pick up your affidavits. All right. We're going to have a bus. We're going to be ready to go. And we're going to pick up these 600 box affidavits from all of you when you guys come out to listen to me and watch me as we do the victory lap around this country and we win this case before we even reach Washington, D.C., because that court is going to concede. All right. The moment that we get this docket number is the moment that the tour will start. We will have 40 days from that moment until we have oral arguments. And that was what we've been planning from the very, very beginning, is 32 press conferences at 32 state capitals over the course of 40 days. All right. That is the tour. That's what we're preparing for. And that's when we're going to pick up all of these affidavits from all of you. Hold them on site, guys. Don't worry about whether or not they've been sent. Don't worry about if they've been returned. Just hang on to them for a little bit longer. I'll pick them up when I see all of you out there in the field, when I come to your state and I argue and present this to the news for all of you within your particular location. Okay, guys, I got to go right now. Thank you guys so much. And their alliance is to the Bar Association. But here's the problem, right? The Bar Association follows the English common law. In England, judges do create law, right? Because the monarch, the king, has granted his agents the authority to be able to speak the law. So in England, judges do create law, right? They do have the authority to create law, but not here in America. We did not delegate the authority here in America for the judges to be able to create law, because we created the court, we created the separation of powers through the legislative branch. All legislative power is vested in Congress of the United States. All power to create law is vested in the legislative branch. The judicial branch has no authority whatsoever here in America to create law. Therefore, if you create a ruling and you erroneously call it law, that is unconstitutional, because you just overstep separation of powers. Judges do not get to create law here in America. They may very well be able to do it in England, but not here in America. So what they brought in here from the English bar is bullshit. It's not fucking real. It's not valid. Stare decisis has no place in American jurisprudence. Case law has no relevance to American jurisprudence. And everything that these judges have put into place that they erroneously called law because they think that they can speak the law, they're fucking wrong, because here in America, we do not delegate the authority for judges to be able to speak the law. That may be true in England, but it's not true here in America. And we're going to fix this, right? Thank you guys so much. God bless. Please, if you can, donate. We have Cash App, Chime, Venmo, PayPal. They're all We Shall Be Free. That's WESHALLBEFREE. We Shall Be Free. That's the only Cash App, Chime, Venmo. That's the only one that we have. If anybody else asks you to donate to any other source, it's not coming to the tour. It's not from anybody on the tour. Please, if you can, donate. But please also get out there, like, share, follow, and comment on these. Let's try to keep as much of these in our queue as possible. And guys, together we shall be free. All right. Love you guys so much. It's been a real honor to be able to serve you guys. And we're getting to the tail end, guys. We're getting to the tail end. So this week, this weekend right now, or the next 2 days, we're going to be serving these next 3 states. We're going to be bringing them on board. That's going to take us to 42 states served. 42 states. All right. And, man, all we can do is just continue to push forward. Love you guys so much. Thank you for letting me serve you. And together we shall be free. All right. Thank you, guys. God bless. Thank you, Facebook. We'll talk here. Thank you, YouTube. Thank you guys so much. God bless. Thank you.